Seated. Everyone else may be seated at this time, ladies and gentlemen. Gentlemen of the jury, I apologize. I have to catch myself on that. Gentlemen of the jury, good morning and welcome back. Thank you for coming back. It's not like you had a whole lot of choice in the matter, but thank you for being here. Again, we greatly appreciate you and thank you for your very important civic duty and your service with us throughout the course of this trial. The first question that I need to ask you, and simply require a show of hands if it is an affirmative answer, was anybody exposed from the time you left the courtroom yesterday and the time you've returned this morning to anything about this case, either through social media, discussion, conversation, or any relation to this case? Exposure, by show of hands. Let the record reflect there are no hands. Again, thank you very much. I will be required to ask you that after breaks and things like that. And I will, before we break, remind you not to do any of that. I apologize for that, but it is important that I do it. I indicated to you yesterday that throughout the course of the trial, the judge, myself, would be giving you instructions that are required. The beginning instructions are called preliminary instructions. They're not very long. It's only about 4 pages that I will read to you this morning. They also include how a trial proceeds, so you have an idea. I'll give you a heads up. It tells you that the next thing after the instructions are closing arguments, which the attorneys will have an opportunity to give when I'm done with the instructions. So I'm going to go ahead and just so that I don't have to scream when I read the instructions, they're written by the Florida Supreme Court. Every word of them is important, and so I read them so that I don't leave anything out. In fact, it says, ladies and gentlemen of the jury, and I'm going to have to fix that. Gentlemen of the jury, you have been selected and sworn as the jury to try the case of State of Florida versus Trevor Summers. This is a criminal case. Trevor Summers is charged with attempted murder in the first degree with a weapon, kidnapping, sexual battery by a person 18 or older upon a victim 18 or older, child neglect, grand theft motor vehicle, and violation of domestic violence injunction. The definitions of attempted murder in the first degree with a weapon, kidnapping, sexual battery by a person 18 or older upon a victim 18 or older, child neglect, grand theft motor vehicle, and violation of domestic violence injunction will be explained to you later. The state's charging document, which is called an indictment, is not evidence and is not to be considered by you as any proof of guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusation beyond a reasonable doubt against Trevor Summers in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law applicable to the case. After the final instructions are given, you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all the evidence, the argument of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss this case among yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, notify court personnel of the violation. During the course of the trial, the court may take recesses and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you are on the jury trying the case and ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during recesses, but even then, you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off at the end of the case. While you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact phone number will be provided to you. The case must be tried by you only on the evidence presented during the trial, in your presence, and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case, the people and places, or the people and places involved in the case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see places discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, the trial judge has no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt. And the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections that they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences do occur, they will be conducted so as to consume as little of your time as is necessary for a fair and orderly trial of the case. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You have been provided with a notepad and pen for use if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom. During recesses, the bailiff will take possession of your notes and will return them to you when we reconvene. After you have completed your deliberations, the bailiff will deliver your notes to me. They will be destroyed. No one will ever read your notes. If you do take notes, do not get so involved in the note-taking that you become distracted from the proceedings. Your notes should only be used as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. That's all of the instructions. I'm going to go ahead and turn that off. And just a couple of things before we get started. Take out those pens and take them for a test drive on your pad. We recycle pens. They ultimately run out of ink. I want to make sure that we start off with all of your pens working. And I want to let you know, please do not be shy. If at any time your pen runs out of ink, or if you're having trouble finding a pen, perhaps, is there an issue with? Yeah, I'm not familiar with Mr. Balcu. Are you not finding it? Yeah, I found it. You found it? All right. Thank you. Go ahead and take it for a test drive. Make sure they work. If at any time, if you need a new pen now, Deputy Estate will get it for you. If at any time during the course of proceedings your pen runs out of ink, and trust me, it happens, raise your hand, get my attention, get the deputy to your right's attention. He's got a supply of new pens. We'll get to you right away. So thank you for that. At this time, now that it looks like everyone's pen is in working order, I'm going to turn to the state and ask them if they wish to give an opening statement. You may proceed.